Law expert William Booth now, who's joining us in our Cape Town studios. A very good morning to you and thank you so much for your time. Well, the prosecution and defense spent the better part of the weekend gathering evidence and preparing for the bail application. What would they have focused on, in your opinion?
Good morning. Well, let's start with the prosecuting authorities. We've heard that they're trying to establish premeditated or planned murder. Obviously, that's going to be extremely difficult. I would feel they have to certainly have evidence of that. There has been much talk and speculation in the media as to what exactly happened. If this was an incident as a result of an argument, for example, certainly the state is not going to be able to establish that it's premeditated murder. Other factors that they may focus on is obviously whether he's a flight risk. I don't particularly think there's going to be a chance of that. The court would also have to look at whether he might interfere with witnesses or if there's a likelihood that he might commit a crime again should he be released on bail. If one looks at what the defense is going to try and place in front of the court, and one must remember that if it's either a Schedule 5 or a Schedule 6. Schedule 6 offence is where it's established that it's premeditated. There's an onus on Mr. Pistorius to convince the court that he should be released. So the defence will be focusing on that. They will also have to look at whether or not he's a flight risk, and in that regard they will present evidence relating to all his personal circumstances and the fact that he's likely to stand trial and that he won't interfere with state witnesses. They may call witnesses to establish that. One must not forget this is not a trial. The state would then be trying to present through the investigating officer or other members of the investigating team why they feel Mr. Pistorius should not be granted bail.
Let me just jump right in there, if I may. You've talked on Schedule 6 offence, and this has been a word or a phrase that's been thrown around quite extensively in the weekend. Quickly just describe the difference between a Schedule 5, which the defence is calling for, and a Schedule 6 offence.
Well, the difference is that with a Schedule 5 offence, there's an onus on an accused person to establish that he should be released in the interest of justice. With the Schedule 6 offence, there's an added aspect in addition to establishing that it's in the interest of justice, and that is whether there are any special circumstances. But I think at the end of the day, the courts in South Africa usually look at whether or not an accused person is a flight risk and whether he's likely to interfere with the investigation or interfere with any potential witnesses. The onus is the big aspect. Normally in our criminal justice system with a trial, the state has to prove beyond a reasonable doubt that somebody's guilty of a crime. With regard to bail applications, there's an onus on an accused person to convince the court that he should be released.
Mr. Booth, there's always the aspect of the trial by media, if I may call it that. I mean, we saw in weekend newspapers alleged details of this particular incident spewed across major Sunday newspapers. How do you think that will affect the trial, or at least the bail application?
Well, certainly in the last few years in South Africa, with regard to certain high-profile cases, if I may call them that, there's been a lot of media involvement. The media have tried to be present during court hearings, in other words, tried to televise court hearings. And obviously, in any case, the media reporting aspects are set out in the newspapers, information that the media have obtained, I'm not sure from where. Surely the police investigating team would not be releasing information about the case. That should be released in court for the first time. But with any trial or with any bail application, my feeling is the media does play an influence. Although we don't have a jury system here, certainly the presiding officers dealing with these kind of cases, magistrates and judges, I feel can be influenced. Whether they want to or not, there's that fact that they read the newspapers and they listen to television broadcasts. So Yes, there can be influence.
And very quickly, in your opinion, do you think, based on what you've told me about that he's not a flight risk, etc., do you think he will be granted bail? And if so, what are the pros and cons of being granted bail?
Well, it's my personal opinion that he should be granted bail. If you look at all the factors, and even regarding that it is a serious crime, and I feel the state is going to have difficulty, as I said, proving that it was planned, bail under certain strict conditions, a fairly high amount of bail with conditions restricting movement in and out of South Africa. And bearing in mind again, in terms of our law, everybody is presumed to be innocent. And we're not busy here with a trial. I think people tend to forget that. Trial by media, and everybody says a lot of things. That has to be determined when the actual trial is presented and when all the witnesses testify.
Thank you so much for your time. Sorry, I'm going to have to
be released on bail.
So you believe he should be released on bail, and we'll find that out tomorrow when the bail application is heard at the Pretoria Magistrates Court. Again, my apologies for interjecting there. Thank you so much for your time. Criminal law expert William Booth, unpacking the legal aspects of a murder case.